My name is Martha, and I am 28 years old. 3 months ago, I stood in the courthouse parking lot after burying both my parents, never imagining that my older brother Harold would become my worst enemy. Our childhood home, our father's small landscaping business, a modest inheritance that should have brought us together in grief instead tore us apart in the most vicious legal battle I could never have imagined. Harold, who had been absent for years, suddenly appeared with lawyers and accusations demanding every single cent of what our parents left behind. But when that judge opened one sealed envelope in court, everything changed in ways none of us saw coming. Before we dive into this story, I would love to know where you are watching from. Please hit that like button and subscribe, because what happened next will show you that sometimes the truth has a way of protecting those who truly deserve it, even from beyond the grave. Growing up in suburban Lima, Ohio, I always believed we were the perfect American family. Our father Robert owned a modest landscaping business that kept food on the table and a roof over our heads, while our mother Agnes worked part-time at the Lima Public Library, surrounded by the books she loved so dearly. We lived in a cozy three-bedroom ranch house on Maple Street, with a front yard that showcased Dad's professional skills and a backyard where Mom grew vegetables every summer. Harold was 5 years older than me, and from my earliest memories it was crystal clear that he was the golden child who could do absolutely no wrong. He got the larger bedroom upstairs with the better view, while I was relegated to the smaller room that faced the neighbor's garage. When school shopping time came around each fall, Harold received brand new clothes from the department store, while I learned to appreciate hand-me-downs and clearance rack finds. Every Saturday during baseball season, both parents would pack into the old Buick to cheer Harold on from the bleachers. But when my school plays or academic competitions rolled around, there always seemed to be some landscaping emergency or library obligation that prevented them from attending. I learned early that love in our household was measured differently for each child. Harold's B- was celebrated with dinner at his favorite restaurant, while my straight A report cards were met with a simple nod and the expectation that this was simply what Martha did. When Harold struggled with algebra, Dad hired an expensive tutor, but when I needed help with calculus, I was told to figure it out myself because I was naturally smart enough. By the time I turned 15, I had already started working part-time jobs to buy my own clothes and save for college. I babysat for neighbors, worked weekends at the local grocery store, and spent summers helping Dad with his landscaping business when he needed extra hands. Harold, meanwhile, focused entirely on his baseball dreams and social life, never expected to contribute financially to anything. The pattern continued through high school. Harold received a partial baseball scholarship to Ohio State University, and our parents borrowed money to cover the remaining costs, proudly telling everyone in town about their son, the college athlete. When graduation came, they threw him a huge party and bought him a brand new car for college. When my turn came 2 years later, they handed me a savings account statement showing $3,000 and suggested I consider the local community college to save money. I was not bitter exactly, but I was certainly realistic about my place in the family hierarchy. Harold was the investment, the pride and joy, the child with unlimited potential. I was the dependable one, the helper, the daughter, who would figure things out on her own because that is simply what Martha did. College took Harold to Columbus, where he discovered business classes and big city ambitions. His visits home became less frequent, starting with missing Thanksgiving his sophomore year for an internship opportunity. By his senior year, we were lucky to see him at Christmas, and even then he spent most of his time on his phone networking with classmates or planning his next career move. After graduation, Harold landed a position with a commercial real estate firm in Denver, Colorado. The distance became his excuse for everything. Too far to travel for birthdays, too expensive to visit for holidays, too busy building his career to attend family gatherings. He sent occasional checks for Christmas and Mother's Day, always with notes about how his business was growing and how proud our parents should be of his success. Meanwhile, I stayed local and enrolled at Rhodes State College studying business administration, while continuing to help Dad with his landscaping work during busy seasons. I understood the equipment knew the clients and genuinely enjoyed the physical work and creative challenges of landscape design. Mom often said I had inherited Dad's green thumb and artistic eye, though she always added that it was such a shame I could not do something more professional with my talents. As our parents entered their 60s, their health began to show signs of wear. Dad's knees suffered from decades of physical labor, and Mom developed diabetes that required careful monitoring and medication management. Harold sent larger checks but never visited, always claiming work commitments or travel restrictions. I found myself becoming their primary support system, driving them to medical appointments, helping with grocery shopping, and gradually taking over more responsibilities with the landscaping business. The transition was so gradual that none of us really acknowledged how much my role had evolved. I started staying overnight when Dad had surgery on his knee. I began managing the business bookkeeping when Mom's eyesight made it difficult for her to read the small print. I moved back into my childhood bedroom when they both caught pneumonia one winter and needed round-the-clock care. Harold knew about all of this, of course. Our monthly phone calls always included updates about health concerns and doctor appointments. He would listen politely and ask appropriate questions, sometimes offering to pay for medical expenses or household improvements. But he never once suggested visiting or taking time off work to help with their care. I tried not to resent his absence, understanding that his career demanded long hours and that Denver really was quite far from Ohio. But late at night, when I was helping Dad to the bathroom or checking Mom's blood sugar levels, I sometimes wondered what it would be like to have a sibling who actually shared these responsibilities instead of just writing checks from a distance. By the time our parents reached their 70s, I had essentially become their live-in caregiver while maintaining my own part-time work and managing increasing responsibilities with the family business. Harold had become a successful commercial real estate developer with his own firm, sending generous financial contributions, but remaining physically and emotionally distant from the daily realities of aging parents who needed more than money to maintain their independence and dignity. The call came on a Tuesday morning in February, during one of Ohio's worst winter storms in decades. A semi-truck had jackknifed on Interstate 75, causing a multi-vehicle accident that claimed both our parents instantly. They had been driving to Mom's doctor appointment in Toledo, a routine visit that had been rescheduled twice due to weather. Dad, always stubborn about his driving abilities, had insisted they could make the trip safely despite the warnings about black ice and blowing snow. I received the news from a highway patrol officer who found my number as their emergency contact. The shock was so complete that I remember dropping the phone and standing motionless in my kitchen for what felt like hours, unable to process that both parents were gone in a single moment. After years of gradual health decline and increasing care needs, I had prepared myself for individual losses, lengthy hospital stays, and difficult end-of-life decisions. I never imagined they would leave together suddenly and completely. Harold flew in from Denver the next day, arriving at the funeral home with expensive luggage and a black suit that probably cost more than my monthly rent. He looked successful and polished every inch the prosperous businessman, but also somehow smaller than I remembered. We had not seen each other in nearly 2 years, and the physical changes were startling. His hairline had receded significantly, and he carried himself with a nervous energy that seemed at odds with his professional appearance. The funeral arrangements revealed our different approaches to grief and family obligation. I had already met with the funeral director, selected modest but dignified caskets, and planned a simple service that reflected our parents' humble lifestyle and practical values. Harold immediately began upgrading everything, insisting on premium caskets, elaborate flower arrangements, and catered reception that would properly honor their memory. He made these decisions loudly and publicly, ensuring that everyone present understood that he was paying for the improvements. During the viewing, Harold positioned himself near the entrance, accepting condolences with practiced grace and frequently mentioning the costs of the upgraded arrangements. He spoke eloquently about our parents' legacy and his own success, somehow managing to make their funeral partly about his achievements. Meanwhile, I found myself overwhelmed by the genuine grief and loss struggling to make conversation with well-meaning neighbors and family friends who had watched me care for Mom and Dad through their declining years. The will reading was scheduled for the day after the funeral held in the modest office of George Patterson, the elderly attorney who had handled our parents' legal affairs for over 30 years. Harold arrived early with a leather portfolio and expensive pen, looking like he was prepared for a business negotiation rather than a simple estate distribution. I brought only a small purse and a heavy heart, still processing the reality that our parents were truly gone. Mr. Patterson read through the standard legal language explaining that our parents had left everything equally divided between their two children. The house was appraised at approximately $200,000, the landscaping business and equipment valued at roughly $50,000, with modest savings accounts and life insurance policies, bringing the total estate to just under $300,000. Split equally, we would each inherit about $150,000, a life-changing amount for me, but probably insignificant compared to Harold's business ventures. Nothing about the will seemed unusual or controversial. Our parents had made practical decisions about asset distribution, appointed me as executor due to my local presence and familiarity with their affairs, and included standard provisions about debt settlement and tax obligations. Harold listened intently, taking notes and asking detailed questions about property assessments and business valuations, but his demeanor remained professional and appropriate. The transformation happened immediately after we left Mr. Patterson's office. As we stood on the sidewalk outside, Harold's entire personality shifted like someone had flipped a switch. The grieving son disappeared, replaced by a suspicious and aggressive stranger who began questioning every aspect of the estate distribution. He demanded to know why I had been appointed executor, why certain assets were valued so low, and what expenses I had charged to our parents during my years of caregiving. The accusations started small but escalated quickly. Harold suggested that I had been living rent-free while he had been supporting himself independently. He questioned whether I had been appropriately compensating our parents for my help with the business. He demanded receipts for medical expenses, household improvements, and grocery bills from the past 5 years, implying that I had been taking advantage of their generosity and failing health. By the time we reached our parents' house, Harold was in full attack mode, accusing me of manipulating elderly and vulnerable adults for my own financial gain. He claimed that I had isolated them from him deliberately, making them dependent on my care while poisoning their minds against their successful son. He threatened to contest the will, hire investigators, and expose what he called my systematic elder abuse through the legal system. I was completely blindsided by this sudden assault on my character and motives. The brother I had grown up with, admired, despite his favored status, and mourned alongside for our shared loss, had transformed into a stranger who viewed me as an enemy and obstacle to his inheritance goals. Harold was no longer interested in family relationships or shared grief. He saw our parents' death as a business opportunity, and me as a competitor who had gained unfair advantage through proximity and manipulation. That night alone in the house where I had spent the last 5 years caring for our aging parents, I finally understood that Harold had never seen our arrangement as sacrifice or family obligation. He had viewed my caregiving as a strategic investment in my own inheritance, a calculated move to gain favor and control over our parents' assets. In his mind, I had been playing a long game of manipulation and influence, positioning myself to maximize my share of their estate. The realization was devastating, not just because of Harold's accusations, but because of what they revealed about his fundamental character and values. This was not grief-talking or temporary stress from funeral arrangements. This was Harold showing me exactly who he had become during his years of success and independence, and exactly how he viewed family relationships in terms of financial advantage and competitive positioning. Within a week of the funeral, Harold had returned to Denver and hired Patricia Morrison, one of the city's most expensive estate litigation attorneys. The legal documents arrived at my door via certified mail, thick envelopes filled with accusations that made my blood run cold as I read through each carefully crafted allegation designed to paint me as a predatory caregiver who had systematically exploited our vulnerable parents. The lawsuit claimed that I had exercised undue influence over Robert and Agnes during their final years, isolating them from Harold and manipulating their judgment through emotional dependency and financial control. The documents accused me of elder abuse, fraudulent conversion of assets, and breach of fiduciary duty, requesting complete investigation of all financial transactions and potentially overturning the entire will based on claims of coercion and mental incompetence. Harold's legal team had done their homework thoroughly. They outlined every instance where I had been involved in our parents' financial decisions, from helping them set up automatic bill payments to accompanying them to bank appointments when their arthritis made writing difficult. Normal caregiving activities were reframed as evidence of systematic control and manipulation, creating a narrative where my presence and assistance became proof of malicious intent. The accusations were as detailed as they were false. The lawsuit claimed I had forged checks, intercepted mail, and prevented Harold from communicating with our parents through deliberate interference and scheduling manipulation. It suggested that I had convinced them to change their wills multiple times, gradually increasing my inheritance while diminishing Harold's rightful share through psychological pressure and emotional blackmail. Reading these documents felt like being punched in the stomach repeatedly. Every sacrifice I had made for our family was twisted into evidence of criminal behavior. Every night I had spent monitoring Dad's breathing after his heart surgery became proof that I was isolating him from other family members. Every grocery shopping trip and medical appointment was characterized as an opportunity for financial exploitation and mental manipulation. I could not afford an attorney like Patricia Morrison. My savings had been depleted by years of reduced work hours and increased caregiving expenses, and the inheritance was tied up in litigation until these issues could be resolved. I found Gerald Thompson, a local attorney who specialized in estate cases and was willing to work on contingency, but even he seemed overwhelmed by the scope and expense of Harold's legal assault. Gerald explained that defending against these allegations would require extensive documentation, expert witnesses, and potentially months of expensive litigation. Harold's team was requesting 5 years of bank records, medical files, and testimony from everyone who had interacted with our parents during their final years. We would need to prove that every financial transaction was legitimate, every decision was made with clear mental capacity, and every action I had taken was motivated by genuine care rather than inheritance planning. The discovery phase of litigation became a nightmare of invasive investigation and character assassination. Harold's attorneys requested copies of every check I had written on our parents' behalf, every credit card statement from accounts where I was an authorized user, and detailed explanations for every expense that could possibly be construed as personal benefit rather than legitimate caregiving cost. They deposed our family doctor, asking leading questions about our parents' mental state and decision-making capacity during their final years. They interviewed neighbors about my behavior and our parents' apparent independence, twisting casual observations into evidence of suspicious control and isolation. They hired forensic accountants to analyze years of financial records, searching for any evidence of inappropriate spending or personal enrichment. The process was humiliating and exhausting. I had to justify every purchase, every decision, every moment of care I had provided. Grocery receipts became evidence of personal benefit when they included items I might have consumed. Utility payments were questioned as inappropriate when I had been living in the house to provide care. Medical co-pays that I had covered were characterized as suspicious loans that our parents had been pressured to accept. Meanwhile, Harold gave interviews to anyone who would listen, positioning himself as the victim of systematic elder abuse and financial manipulation. He spoke eloquently about the pain of losing his parents, while discovering that his sister had taken advantage of their trust and vulnerability. He hired a public relations consultant to manage his image, ensuring that local media coverage portrayed him as the successful son, fighting to protect his parents' memory from exploitation. The community reaction was devastating. Lima is a small town where everyone knows everyone else's business, and the inheritance dispute became the subject of constant gossip and speculation. Some people supported me, knowing how devoted I had been to our parents during their illness, but others whispered that maybe Harold had a point about my living situation and financial arrangements. Former clients of the landscaping business were subpoenaed to testify about our parents' mental state and my role in business operations. Neighbors were questioned about whether they had observed signs of coercion or inappropriate influence. Even our parents' longtime friends were drawn into the legal battle, forced to choose sides and provide testimony about family dynamics they had observed over decades of friendship. The stress was overwhelming and constant. I developed insomnia, anxiety attacks, and a persistent feeling that everyone was watching and judging my every move. Simple activities like grocery shopping or banking became exercises in paranoia, wondering if someone was taking notes on my behavior or reporting back to Harold's investigation team. The weight loss and emotional exhaustion were obvious to everyone who knew me, creating additional concerns about my stability and judgment. 6 months into the litigation, Harold's legal team uncovered what they considered their smoking gun evidence. During their forensic investigation of our parents' financial records, they discovered an old checking account that I had used to manage their household expenses during the final 2 years of their lives. The account had my name as a joint holder, and the transaction history showed thousands of dollars in deposits and withdrawals that, without proper context, looked exactly like systematic financial exploitation. Patricia Morrison filed an emergency motion with the court presenting this checking account as definitive proof of my fraudulent behavior and financial manipulation. The legal documents painted a picture of systematic theft, showing how I had deposited our parents' Social Security checks, pension payments, and insurance reimbursements into an account under my control, then withdrawn money for various expenses that could not be adequately documented or justified. The reality was completely different, but explaining the truth required extensive documentation that was difficult to reconstruct after our parents' death. They had asked me to set up this account specifically to handle their bills and expenses, recognizing that their arthritis and declining vision made check writing and financial management increasingly difficult. The deposits were their income sources that they had specifically directed into this account for easier management, and the withdrawals were for legitimate household expenses, medical costs, and business operations that they had approved and often requested. But without our parents alive to testify about these arrangements, the account looked exactly like what Harold's attorneys claimed it was: a sophisticated scheme where I had gained control over their finances through manipulation and convenience, then systematically diverted their money for my own purposes while maintaining the appearance of legitimate caregiving expenses. The local newspaper picked up the story, running a front-page article about the inheritance dispute that focused heavily on this financial evidence. The headline read, "Local Woman Accused of Elder Abuse in Inheritance Battle," and the article included quotes from Harold describing his shock and disappointment at discovering his sister's alleged betrayal of their parents' trust. Harold gave a carefully scripted interview that portrayed him as the heartbroken son who had trusted his sister to care for their aging parents, only to discover that she had been systematically exploiting their vulnerability for financial gain. He spoke about the difficulty of pursuing legal action against his own family member, but emphasized his obligation to protect their parents' memory and ensure that justice was served. The media attention was mortifying. People I had known my entire life began treating me differently, some with obvious suspicion, and others with awkward sympathy that was almost worse than outright hostility. Former friends crossed the street to avoid conversation, and casual acquaintances stopped making eye contact when we encountered each other in public places. Harold's team also located several neighbors who were willing to testify about my allegedly controlling behavior during our parents' final years. These witnesses described how I seemed to manage our parents' schedule, completely screening their phone calls and making decisions about their medical care without consulting Harold. They testified about observing our parents becoming increasingly dependent on my presence and assistance, suggesting that I had deliberately created this dependency to maintain control over their lives and finances. What these witnesses described was actually normal caregiving behavior for elderly adults with increasing physical limitations and health concerns. I had helped screen calls because our parents were receiving constant solicitations from scammers targeting seniors. I had managed their schedule because they needed assistance remembering appointments and coordinating transportation. I had been involved in medical decisions because they had specifically asked me to advocate for their needs when they felt overwhelmed by complex healthcare systems. But presented in court by Harold's expensive attorneys, these normal caregiving activities sounded sinister and manipulative. The witnesses painted a picture of gradual isolation and control that made me appear to be a predatory caregiver who had systematically separated our parents from their successful son while increasing their dependence on my assistance and presence. The financial pressure of defending against these accusations was overwhelming. Even with Gerald working on contingency, there were court costs, expert witness fees, and investigation expenses that I could not afford. I had to sell my small condominium to pay for forensic accounting and medical expert testimony needed to defend against Harold's accusations. Moving back into our parents' house while it was tied up in litigation felt like living in limbo. Every room contained memories of the care I had provided, but also reminders of the accusations Harold was making about my motives and behavior. I was living in a home that might be taken away from me if Harold's legal team could convince a judge that I had manipulated our parents into favoring me in their will. The stress began affecting my physical health in ways that Harold's attorneys immediately seized upon as additional evidence against me. I developed panic attacks that required medication, insomnia that left me exhausted and emotional, and anxiety that made simple daily activities feel overwhelming and impossible. When I sought therapy to cope with the trauma of the legal battle, Harold's team suggested that my emotional instability proved their claims about my undue influence over vulnerable elderly adults. The night before the trial was scheduled to begin, I sat in our parents' bedroom surrounded by photo albums and letters that documented decades of family memories. I found thank you cards they had written to me over the years, expressing their gratitude for my help and support. I discovered letters they had written to friends describing their appreciation for my sacrifice and devotion to their well-being. But I also found evidence of their growing concern about Harold's absence and apparent disinterest in their daily lives. There were appointment cards where they had hopefully written his name, then crossed it out when he canceled or failed to show up. There were birthday cards they had bought for him, but never sent because he had not called or visited. There were photographs of family gatherings where Harold was conspicuously absent, leaving empty spaces at holiday tables and graduation celebrations. Reading through these documents, I realized that our parents had been quietly heartbroken by Harold's distance and indifference, but had never complained or criticized him to me directly. They had maintained hope that his success and independence were temporary barriers to family connection, and that eventually he would return to the close relationship they remembered from his childhood and college years. I also realized that they had been carefully documenting my care and assistance, not because they suspected I was exploiting them, but because they wanted to ensure that my sacrifices were recognized and appreciated. They had been building a record of my devotion and support, perhaps anticipating exactly the kind of accusations Harold was now making about my motives and behavior. Sitting in their bedroom at 2 a.m, surrounded by evidence of their love and gratitude, I made the decision to fight this battle through to the end, regardless of the personal cost or emotional toll. I owed it to their memory to defend the truth about our relationship and my caregiving, and I owed it to myself to stand up against Harold's cruel and baseless accusations about my character and motivations. The trial began on a cold Monday morning in November, with Judge Elizabeth Warren presiding over what had become the most talked-about legal case in Lima's recent history. The courtroom was packed with curious spectators, including many people who had known our family for decades and wanted to witness the resolution of this bitter inheritance dispute. Patricia Morrison's opening statement was polished and devastating, painting me as a calculating predator who had systematically exploited our vulnerable parents for financial gain. She outlined a timeline of increasing control and influence, describing how I had gradually isolated Robert and Agnes from their successful son while creating dependency relationships that served my own inheritance interests rather than their genuine well-being. She presented the joint checking account as the centerpiece of her case, arguing that this financial arrangement proved my fraudulent intent and systematic exploitation. Morrison showed the jury bank statements highlighting large deposits and withdrawals, emphasizing the amounts of money that had flowed through an account under my control without adequate oversight or documentation. Gerald's opening statement focused on the basic facts of family caregiving and filial responsibility. He reminded the jury that someone had to help our aging parents with daily activities, medical appointments, and financial management, and that Harold had been completely absent from these responsibilities for years. Gerald emphasized that every penny spent from the joint account could be documented as legitimate expense for our parents' care and household needs. Harold took the witness stand first, delivering a smooth and polished performance that demonstrated exactly why he had been successful in commercial real estate. He spoke eloquently about his love for our parents and his regret about being unable to provide more hands-on care due to geographic distance and professional responsibilities. He claimed that he had wanted to be more involved in their final years, but that I had systematically prevented his participation and gradually taken control of all family decisions. Harold described phone calls where our parents seemed different, more dependent, and less sharp than he remembered. He claimed that I was always present during these conversations, influencing their responses and limiting their ability to speak freely about their needs and concerns. He testified that he had grown increasingly worried about their mental state and my level of control over their daily activities. Under cross-examination, Gerald exposed some inconsistencies in Harold's testimony. When pressed about specific dates and visits, Harold could not provide clear details about his last several trips to Ohio or his involvement in our parents' medical care. Gerald showed the jury Harold's own phone records demonstrating that his calls to our parents had been infrequent and brief, hardly the pattern of a concerned and involved son. Harold's witnesses included 3 neighbors who testified about observing my controlling behavior and our parents' increasing dependence on my presence. They described incidents where I seemed to speak for our parents, made decisions about their activities, and appeared to monitor their interactions with other people. One neighbor testified that our father had mentioned feeling overwhelmed by medical appointments and financial decisions, suggesting that he was no longer capable of managing his own affairs independently. Another witness was Dr. Richard Phillips, our parents' former physician, who had retired 6 months before their death. Dr. Phillips testified that our parents had seemed more anxious and confused during their final appointments, asking fewer questions and deferring to my judgment about treatment decisions. He suggested that this could indicate declining mental capacity or undue influence from a dominant caregiver. Under Gerald's cross-examination, however, Dr. Phillips admitted that anxiety and confusion were normal responses to complex medical conditions and aging processes. He acknowledged that family caregivers often served as advocates and interpreters for elderly patients, and that my presence at appointments had actually improved our parents' understanding and compliance with treatment recommendations. The prosecution's star witness was Dr. Amanda Foster, a forensic accountant who had analyzed 5 years of our parents' financial records. Dr. Foster testified about patterns of spending and account management that she characterized as suspicious and potentially fraudulent. She highlighted the joint checking account as an unusual arrangement that created opportunities for exploitation and asset diversion. But Gerald's cross-examination revealed that Dr. Foster had never interviewed our parents about their wishes and intentions regarding the account arrangement. She had no evidence that any money had been spent inappropriately or without their knowledge and consent. Her analysis was based purely on transaction patterns without context about the legitimate caregiving expenses and household management needs that these transactions represented. When I took the witness stand, I felt the weight of everything depending on my ability to tell the truth clearly and convincingly. I described the gradual process of becoming our parents' primary caregiver, emphasizing that these responsibilities had evolved naturally in response to their increasing needs, rather than through any manipulation or planning on my part. I testified about the joint checking account, explaining that it had been our parents' idea to simplify their bill paying and expense management. I provided detailed explanations for major expenditures, showing receipts and documentation for medical expenses, household repairs, and business costs that Harold's team had characterized as suspicious or inappropriate. The most emotional part of my testimony involved describing our parents' daily routines and care needs during their final years. I explained how I had helped them maintain their independence and dignity while providing necessary assistance with activities that had become difficult or dangerous for them to manage alone. I testified about their gratitude for my help and their explicit requests for me to handle various aspects of their financial and medical care. Gerald also called several character witnesses who had observed my relationship with our parents over many years. These included longtime clients of the landscaping business neighbors who had known our family for decades and medical professionals who had worked with us during our parents' final illnesses. Each witness testified about my genuine devotion and appropriate caregiving behavior. Sarah Mitchell. Our parents' primary care physician during their final 2 years provided crucial testimony about their mental capacity and decision-making abilities. She confirmed that both Robert and Agnes had remained mentally sharp and capable of making informed decisions about their care and finances until the very end of their lives. She described their appreciation for my assistance and their clear understanding of all financial arrangements we had discussed during medical appointments. The financial evidence portion of the trial involved detailed examination of bank records, receipts, and expense documentation. Gerald methodically walked through every major transaction from the joint checking account, providing clear explanations and supporting documentation for each expenditure. The evidence showed that every penny had been spent on legitimate expenses for our parents' care, household needs, or business operations. Harold's forensic accountant had to admit under oath that she could find no evidence of personal enrichment or inappropriate spending. While the account arrangements were unusual, all the money had been used for purposes that benefited our parents, rather than serving my personal interests. The systematic theft and exploitation that Harold had alleged simply could not be supported by the actual financial evidence. As the trial progressed, it became clear that Harold's case was based more on suspicion and innuendo than concrete evidence of wrongdoing. His attorneys had created a compelling narrative about caregiver exploitation, but they could not prove that any actual exploitation had occurred. The joint checking account looked suspicious in isolation, but when examined in context of our parents' legitimate care needs and explicit instructions, it appeared to be exactly what I claimed it was. On the final day of testimony, just as both sides were preparing their closing arguments, the court clerk approached Judge Warren with a manila envelope that had been filed separately in the court records. The clerk explained that this envelope had been marked as sealed, pending the outcome of the main estate proceedings, and that it contained documents related to our parents' estate planning that needed to be reviewed before final judgment. Judge Warren called a recess to examine the contents of the envelope privately. When court resumed 30 minutes later, her expression was grave and her demeanor had shifted significantly. She announced that the envelope contained a second will dated 6 months after the one that had been read by Mr. Patterson, and that this document had been filed separately by our parents' previous attorney who had recently retired and moved to Florida. Harold's face immediately drained of color. Patricia Morrison scrambled to object, claiming that no such document had been disclosed during discovery and demanding time to examine its authenticity. But Judge Warren had already verified the document's legitimacy through handwriting analysis and witness statements that had been filed with the original will. The second will was about to change everything we thought we knew about our parents' final wishes and their understanding of Harold's true character. Judge Warren's voice filled the silent courtroom as she began reading from the second will dated just 6 months before our parents' death. The legal language was similar to the first document, but the asset distribution was dramatically different. Instead of splitting everything equally, this will left Harold exactly $5,000 and our father's old pickup truck, while everything else was bequeathed to me with detailed explanations for this decision. The will included a personal letter from our parents that Judge Warren read aloud in its entirety. The letter began by expressing their deep love for both their children, but continued with heartbreaking revelations about their growing awareness of Harold's true priorities and character during his infrequent visits home. We have always hoped that Harold's success and independence were simply phases in his development, the letter read, but we have come to understand that his absence from our lives reflects his actual priorities rather than temporary circumstances. During his last 3 visits, we overheard phone conversations where Harold discussed our assets and made plans for what he would do with his inheritance after we were gone. The letter described specific incidents where Harold had been more interested in appraising their possessions than spending time with them. They had noticed him taking photographs of valuable items, researching property values online, and asking detailed questions about their insurance policies and financial arrangements. Most painfully, they had overheard him telling someone on the phone that he was just waiting for the old folks to die so he could finally cash in. We were heartbroken but not entirely surprised, the letter continued. Harold has always measured relationships in terms of personal benefit, and we realize now that his financial contributions to our care were motivated by inheritance protection rather than genuine concern for our well-being. The letter went on to praise my devotion and sacrifice in terms that brought tears to my eyes. Martha has given up her own independence and opportunities to ensure our comfort and dignity during these final years. She has never asked for anything in return, never mentioned inheritance or future financial arrangements, and never made us feel like burdens or obligations. Her care has been motivated by love, rather than self-interest. Our parents explained that they had created the second will after consulting with their longtime attorney about their concerns regarding Harold's motivations and behavior. They had wanted to ensure that their assets would go to the child who had actually demonstrated love and commitment through actions rather than just words and money. We ask Martha's forgiveness for not addressing Harold's character more directly during our lifetimes, the letter concluded. We maintained hope that he would eventually mature into the loving son we remembered from his childhood, but we realize now that his success has only reinforced his selfish and materialistic values. We trust that Martha will use this inheritance wisely and continue to honor the family values we tried to instill in both our children. As Judge Warren finished reading the letter, I looked across the courtroom at Harold and saw a man whose carefully constructed facade had completely crumbled. His face was ashen, his hands were shaking, and his expensive attorney was frantically whispering in his ear, while shuffling through legal documents trying to find some basis for objection. Patricia Morrison immediately stood to challenge the document's authenticity and timing, arguing that it should have been disclosed during the original probate proceedings. But Judge Warren had already verified the will's legitimacy through multiple sources, including testimony from the retired attorney who had prepared it and witnessed its execution. The retired attorney William Morrison had been contacted by phone and confirmed that Robert and Agnes had specifically requested this second will after expressing concerns about Harold's behavior and motivations. They had asked him to file it separately from their other estate documents, with instructions that it only be revealed if the original will was contested or if there were disputes about their final wishes. Harold's explosion was immediate and devastating. He began shouting about favoritism and unfairness, claiming that our parents had been manipulated and that this second will proved his point about my undue influence. His outburst was so violent that the bailiff had to physically restrain him, and Judge Warren threatened him with contempt of court if he could not control himself. The transformation was complete and shocking. The polished businessman who had testified so eloquently about his love for our parents disappeared entirely, replaced by a bitter and greedy man whose mask had finally slipped completely. His true character was now visible to everyone in the courtroom, validating exactly what our parents had discovered during his final visits home. Patricia Morrison attempted damage control, arguing that the second will was the product of undue influence and that it proved her case about my manipulation of our elderly parents. But this argument fell apart immediately when confronted with the detailed and specific nature of our parents' observations about Harold's behavior, much of which had occurred during phone conversations when I was not present. Judge Warren called for a brief recess to review all the evidence in light of this new document. When court resumed, she delivered a scathing judgment that not only dismissed all of Harold's claims, but also ordered him to pay court costs and attorney fees for bringing what she characterized as frivolous and malicious litigation. The evidence presented in this case demonstrates that the original will contest was based on false accusations and character assassination, rather than legitimate concerns about testamentary capacity or undue influence, Judge Warren stated. The second will provides clear evidence that Robert and Agnes Peterson were mentally competent and fully aware of their decisions regarding asset distribution. She continued. Furthermore, the detailed observations contained in the second will regarding Harold Peterson's behavior and motivations suggest that his legal challenge was motivated by greed, rather than genuine concern for his parents' welfare or memory. This court finds that Martha Peterson provided exemplary care for her parents, and that her inheritance is fully justified by her devotion and sacrifice. The judgment was complete and final. Harold would receive exactly what our parents had intended, $5,000 and an old truck, while I would inherit everything else, including vindication of my character and caregiving. More importantly, the truth about our family dynamics and Harold's real motivations had been revealed publicly and permanently. As we left the courtroom, Harold avoided all eye contact and hurried away with his attorney, who was already discussing appeal options that would prove futile given the strength of the evidence and the finality of our parents' documented wishes. I felt a mixture of relief, vindication, and profound sadness that our family had been destroyed by Harold's greed, and my parents' hearts had been broken by his true character. The immediate aftermath of the trial brought a strange mixture of relief and profound sadness that took months to fully process. Walking out of that courtroom, I felt vindicated and protected by our parents' love and foresight, but also heartbroken that they had discovered Harold's true nature and had felt unable to address it directly with either of us during their lifetimes. The community reaction was swift and decisive. People who had whispered about my motives and behavior during the legal proceedings now approached me with apologies and embarrassment about their doubts. The newspaper ran a follow-up article with the headline, "Local Woman Vindicated in Inheritance Dispute," detailing how the sealed will had revealed the truth about family dynamics and caregiving relationships. Harold left town within hours of the judgment, returning to Denver without any attempt to reconcile or explain his behavior. His expensive attorney quietly withdrew from the case, and any hopes of appeal were abandoned when legal experts confirmed that our parents' second will was ironclad and legally unassailable. I never heard from Harold again, though mutual acquaintances occasionally reported that his business reputation had suffered significantly from the publicity surrounding his failed legal challenge. The emotional processing took much longer than the legal resolution. I spent weeks reading and rereading our parents' letter, trying to understand how they had maintained such grace and hope while dealing with the private pain of recognizing Harold's character. They had never shared their heartbreak with me directly, instead choosing to protect both their children from the full extent of family dysfunction, while quietly preparing legal protection for the child who had demonstrated genuine love and commitment. I decided to keep the family home, but not before making significant renovations that would transform it from a place of caregiving and conflict into a sanctuary for healing and new memories. Using our father's landscaping expertise and our mother's love of beauty, I created memorial gardens that honored their memory while providing peaceful spaces for reflection and recovery. The landscaping business required careful consideration and planning. Many longtime clients had supported me throughout the legal battle, expressing their appreciation for the care I had provided to Robert and Agnes and their confidence in my ability to continue the family tradition. I decided to maintain the business but expand it to include memorial and therapeutic garden design, using the skills our father had taught me to help other families create meaningful outdoor spaces. Returning to work felt like emerging from a long, dark tunnel into sunlight. The routine of physical labor, creative problem-solving, and client relationships provided structure and purpose after months of legal stress and emotional turmoil. I found particular satisfaction in designing gardens for elderly clients understanding their needs for accessible beauty and low-maintenance landscapes in ways that my caregiving experience had taught me. The inheritance also provided opportunities for giving back to the community that had ultimately supported me through the legal battle. I established a small scholarship fund at the local community college for students pursuing careers in elder care or landscape design, honoring both our parents' values and my own experiences with family caregiving responsibilities. Therapy became an essential part of my healing process, helping me understand the complex emotions surrounding family betrayal, caregiver burden, and sudden wealth. My therapist helped me recognize that Harold's behavior reflected his own character limitations rather than any failure on my part as a sister or daughter. Learning to separate his choices from my own sense of family responsibility took time and professional guidance. The experience taught me profound lessons about the difference between authentic family relationships and superficial connections based on obligation or expectation. Our parents' love had protected me even after their death, while Harold's absence during their lifetime had revealed his true priorities and values. Real family bonds are created through presence, care, and sacrifice, rather than shared genetics or childhood memories. I also learned about my own strength and resilience in ways that I never could have imagined. Fighting Harold's accusations had required me to defend not only my actions, but also my fundamental character and motivations. Standing up to his well-funded legal assault while maintaining my integrity and truthfulness had revealed reserves of courage and determination that surprised even me. The sealed will had provided more than legal protection. It had given me proof that our parents understood and appreciated my sacrifice in ways they had never been able to express directly. Their letter contained the validation and gratitude that every caregiver needs, but rarely receives, acknowledging the cost of my devotion, while confirming that my motivations had been pure and my care had been valuable. 6 months after the trial, I received a package with no return address, containing a brief note and a set of keys. The note, written in Harold's handwriting, simply said, "The truck is in the driveway. I don't want any reminders." I found our father's old pickup truck parked in front of the house, apparently driven from Denver, and abandoned without any further communication or explanation. The truck became a symbol of complex emotions and complicated relationships. It represented our father's practical values and simple pleasures, but also Harold's final rejection of family connections and sentimental attachments. I decided to restore the truck as a memorial project, honoring our father's memory while transforming something Harold had discarded into something beautiful and meaningful. Working on the truck in our father's old garage using tools he had taught me to handle, I found a kind of peace with the family story that Harold's greed and legal assault had tried to destroy. Our parents' love had been real and protective. My care had been genuine and appreciated, and the truth had ultimately prevailed despite Harold's wealth and legal sophistication. Today, 2 years after that terrible trial, I live peacefully in the home where I cared for our aging parents and fought for their memory. The memorial gardens bloom each spring with flowers our mother would have loved, and the landscaping business continues to serve clients who remember our father's skill and integrity. The inheritance has provided security and opportunities, but more importantly, the experience taught me that love and loyalty create their own protections and rewards. Sometimes I wonder what might have happened if Harold had chosen differently, if he had shared caregiving responsibilities or maintained genuine relationships with our parents during their final years. But I have learned that we cannot control other people's choices or values, only our own responses to the challenges and opportunities that life presents. The sealed will that saved my inheritance and vindicated my character was ultimately a gift of love from parents who understood that real family means showing up, caring deeply, and sacrificing willingly for those we love. That lesson guides everything I do now, and I hope it will continue to guide me through whatever challenges and blessings the future may bring. Have you ever had to stand up for what was right when everyone seemed against you? Or maybe you have experienced family betrayal when you least expected it. I would love to hear your thoughts and experiences in the comments below. Please hit that like button if this story resonated with you, and do not forget to subscribe for more real-life stories about family courage and the power of truth. Share this video with anyone who might need to hear that sometimes justice does prevail even when the odds seem impossible. Thank you for listening to my story and for being part of this community where we support each other through life's most difficult challenges. I hope you all find the strength to fight for what matters most and the peace that comes from knowing you have lived with integrity and love.